Thank you, organizers of MAPICON, in particular Dr. Vitull Gupta, for inviting me and being so kind that at every step he's helped me, including this morning's 5 a.m. message that my train would leave from this station and not that. I've been asked to speak on this topic, mistakes doctors make in the courts, but it is so very difficult to be a following speaker after Neeraj Nagpal's emotional talk that I do not know whether I would be able to hold your attention together. But the topic is so emotional as such, what Neeraj told just now, that I am coming from Delhi and I was in the train and I finished writing an article on the same, I do not want to use the word, but on the same diktats that the NMC has given recently of reducing the percentile to 0. Anyway, coming back to my own topic, almost about 2.5 millennia ago, Hippocrates made a statement which is still so relevant. Medicine is of all the arts the most noble, but owing to the ignorance of those who practice it and of those who inconsiderately form a judgment of them, it is at present far behind all other arts. Because now all the patients, or most of the patients, definitely the judiciary, they do not appreciate the fact that medicine is an inexact and imprecise science, an art later. Now, before actually the battle begins, what do? We fritter away the chances of nipping the evil in the bud by missing the cues in a complaint which is destined to become a court case. What are those cues? The outcome starts appearing to be less than expected by the patient, but more often by the relatives. And both the patient and the relatives are in denial of seriousness of disease. There is a complication, even if told earlier that it is inherent. Bill is higher than promised, but more often than expected. There is some actual or perceived communication gap. Patients or the relatives' body language turns aggressive. The mistake that we commit is that we do not inform the insurance company at this stage. You must do so immediately. Then there is a very lackadaisical attitude of all concerned to any such notice, to any such legal proceeding, etc. Why I say that? In fact, it is evident that anything which is concerning the legal aspects of medicine and ethics, the attendance in any conference is so thin. Whenever it comes to them and then the heavens break loose, in fact hell break loose at that particular time, and they cry hoarse. The attitude is very lackadaisical. How? They do not make the right strategy. Strategy should be to win anticipatory battle through successive courts, because there are so many surprises that you are going to face on your way up. The lawyer plays truant, he becomes hand in glove with the opposing lawyers, in cahoots with the opposing lawyers. Insurer refuses to pay the claim. Remember that for everything you have earned, that is at stake. For a lawyer, it is just a job, it's just another case. Your own involvement from complaint to judgment is of paramount importance that I cannot overemphasize. So therefore, you must engage your lawyer wisely. Remember that retaining the insurance company lawyer is not mandatory, whatever they say. Due diligence and the integrity of lawyer is a must. One thing that I would like to emphasize is that we tend to go by the reputation, by the name that lawyer has earned. Remember that reputed lawyers are busiest and they do not have time. Also, they may not be having this focus of attention that is medical, legal or malpractice cases. So, try and make sure that the lawyer has time at hand and specializes, or at least has a focus on these cases. One more mistake that we people do is we do not co-opt a medical legal expert. Remember that judgment is based upon a balance of probabilities as presented to the judge by opposing lawyers. However, unfortunately, both the lawyers of opposing parties and the judge have no clue about intricacies of medicine. Possibly, lawyers know the law, but not medicine at all. And you know the medicine, but not the law. Therefore, you need to know somebody to guide you, to advise you, who as a bridge to the gap, to cover that gap. The case can be prepared and presented in a much better way with an appropriate expert medical legal advice co-opted. There have been scores of cases where the claims have been awarded against the medical establishment or the doctors, but for a very clear presentation. Even the facts have not been represented well, the facts have not been produced before the court. Neeraj just spoke about state medical councils and under National Medical Commission. For the time being, I may say luckily, the regulations have been held in abeyance. But I'm coming to the point that I'm making is that very often the first complaint is either filed directly to the State Medical Commission or is directed by the National Medical Commission to be heard by State Medical Council. Now, defendants means doctors and the hospitals and the medical establishments, do not take it seriously because State Medical Council so far did not have any pecuniary power. It may come now, but so far it has not been implemented yet. The State Medical Council judgment on negligence carries a lot of weight in the escalated matrix of the journey of the case up to the Supreme Court, because this judgment is considered as a judgment by subject experts. Further, presence of an advocate representing the defendant is not allowed. In fact, it has been frowned upon by most state medical councils. On the other hand, if a doctor comes along with his colleague who is a medical legal expert, it is not taken unkindly, if not taken kindly. In the State Medical Council, the case should be presented and put up with all your might behind it for the reasons I have cited above. I have spoken to various lawyers because I could not or I will not be able to find anything in the literature as to what mistakes the doctors commit in the court of law. So what mistakes do the doctors commit in court of law according to the lawyer's perspective? And the first thing they say is that they do not share complete facts truthfully with them. The doctors do not share complete facts truthfully with them. And that is a must. Because if you murdered somebody, unless you tell that you murdered somebody, how is he going to defend you? So if you made a mistake, whatever you feel, if there is a mistake or otherwise, you must share exactly what happened truthfully with your lawyer. Most important, not being involved in day-to-day preparation and progress of the case. You leave everything to the lawyer. Remember that lawyers have a way, especially during cross-examination, to entrap you in a deceptive web of words and make you say what they want you to say, which is at variance with what your actual stand is. And this is where your being jittery, anxious and nervous is exploited by the opposing lawyer. Then Another very common mistake that you do is you try to put the blame on your colleague or someone else. The cases Balram Prasad versus Kunal Saha, where the maximum claim so far has been awarded of 11.6 crores, where they tried to, the consultants tried to put blame on resident doctors. In another case, Bombay Hospital versus Sharifabai Ismail Saeed and others, the consultant blamed the resident doctors for wrong labeling when the Bombay Hospital went into appeal to the National Commission. And the National Commission held that the State Commission committed an error apparent on the face of the record in holding that the consultant cannot be held responsible for the error committed in signing the report on the basis of noting by the senior resident doctor. The case was that an MRI was done and a senior resident noted and marked the lesion at T9 to 11, whereas this resulted in a futile exploration and futile surgery, whereas it should have been marked at T8 to T9. And the consultant signed without actually confirming it. So the National Commission, despite consultant having blamed the residents, came down very heavily on the consultant. Now, I have spoken to Supreme Court judges, members of National Commission, as to what mistakes do the doctors commit in their court. And the first thing that comes is that they do not take this legal notices and the proceedings seriously. They take it very casually, to the extent of even ignoring it and not replying the notice within the stipulated period of 30 days. At the most, in exceptional circumstances, an extension is granted for another 15 days, that too with the permission of court. But if you reply after 45 days, what happens? Extension is not permitted, even with fine. Defense is forfeited under Section 38(2) of Consumer Protection Act 2019, and case is decided on plaintiff's witness and evidence, or it is ex parte decision. Not attending the court in person and relying entirely on the lawyer. Honestly, you do not know what the lawyer is doing. He's just assured you that he'll see through the proceeding and you don't worry. But you do not know how the lawyer is behaving. You do not know what facts has he presented. So you should be there as often as possible, as much as possible in the court in case the case is against you. Again, we tend to go in the court without being prepared with the details of the case. The case has happened several years ago. You don't remember everything. But you must refresh your memory by going through the case just before they attending the court. Because judges may ask some very surprising questions. Further, doctors make irrelevant points and produce inadmissible documents, which actually irritates the court. Once given, remember this is very important, I have bolded the statement. Once given, this statement cannot be changed till disposal of the case. You cannot change your statement. And it is allowed to supplement only if the court so desires in the for the justice in the fairness of the things. Stick to the pointed questions asked by the court and submit only relevant facts and admissible documents. That has been the advice which has given to me by the Supreme Court judge. Not having documentary evidence in support of reference. You don't have documentary evidence of a textbook which you have quoted in your case. Very importantly, not complying the order of the court. In Abhishek Ahluwalia versus Dr. Sanjay Ahluwalia, 2 years jail term was awarded by Union Territory Consumer Dispute Redressal Commission for failing to pay 70 lakh compensation awarded by the National Commission. The doctor is absconding, that's a different story, but you would invite the wrath of the court. Not maintaining the decorum, using phone in the courtroom while the proceedings are going on. That irks the judge. Not observing common etiquette, coming dressed very, very casually and not showing respect to the court. These are certain other points that were observed consistently by this Supreme Court judge who I spoke to. I will come to prudence a little later, but what we do is, doctors are a very sensitive lot. We see that we have been wrong, I must fight. I must resurrect my self-esteem and self-prestige. But remember that a bad settlement is better than good litigation, because litigation goes on for years together. It robs you of your peace of mind, of your effort, of your time. Now that a provision of mediation has been incorporated in the latest Supreme Court Consumer Protection Act 2019, please jump at the offer of mediation if given. Don't think at that particular time that no, I will fight and prove my point. Mediation at the outset appears to be an attractive option to both the parties because it is less formal, less procedural, less overbearing, and is away from public gaze. One can't appeal against the settlement done through mediation. That's very, very important. Otherwise, you go up the ladder from the State Medical Council to the National Medical Council to the District Forum, now Commission, then the State Commission, and the National Commission and the Supreme Court. This cannot even be challenged there. A team of medico-legal expert and a trained lawyer in mediation, that is, a person who's really well versed in negotiating skills, can use the nuances of medicine and law both to mediate between the warring parties rather than taking recourse to litigation. This is what I was talking to you about, prudence. Prudence is one major and probably the most important part of the strategy that you should have. Not filing appeal against the judgment of National Commission, leading the Supreme Court to conclude this as admission of guilt in V. Krishna Kumar versus State of Tamil Nadu. This was a case of retinopathy of the premature, wherein the doctors and the hospital didn't go to in appeal to the Supreme Court, and the opposing party, that is the plaintiffs, they went to enhance their claim. So weigh the odds of going in appeal and fighting to resurrect your self-esteem after having been wrong versus paying up. More so if the insurance company is picking up the tab. Very important point now under the Consumer Protection Act 2019, that if you have to go in appeal against the lower commission, then you have to deposit 50% of the claim amount to the court, to the High Commission. Where will you get it from? For a change, let emotions take backseat. Remember, to let go is not defeat. Criminal negligence, on the other hand, is a different ballgame. Mostly the complaints are filed under IP 304A, but also under other sections like 336, 337 and 338. Now, what does the police do when there is a case filed or a complaint filed? Police exploits your being unsure and underconfident to the hilt. And they would tell you many things essentially to extract some gratification. Make sure, I cannot overemphasize, make sure you exercise your right against filing of an FIR against you soon after the incident. Because the court is very clear, the law is very clear on that. Jacob Matthew has been cited ad nauseum that a doctor cannot be arrested in routine manner. FIR cannot be lodged unless an expert opinion is taken. And in fact, Justice Sadashivam has clearly stated an FIR cannot be filed against lawyers and doctors. All these three judgments are of Supreme Court, therefore they are the law of the land. But the police don't care. And the commonest refrain is that they don't find it in Criminal Procedure Code. And there is a lot of, and they say that there is a lot of pressure from local politicians, high officials, public and media. Therefore, keep a copy of these judgments. It's available in public domain. Keep a copy of these judgments in your premises. You can quote this. Now what happens when there is an unexpected, unexplained death? Don't lose precious time before calling police and contacting your lawyer. You should do it immediately. You call the police before the relatives do. Because once an FIR is filed by the patient party, the case completely takes a different turn. And even if you say that there is a less an FIR of violence, etc., that's a counter FIR. What happens then? The case takes a convoluted and arduous route. And to quash the FIR, you have to really work hard, and that takes precedence than the case itself. Need for a criminal lawyer arises and expenses mount, and you don't even can imagine how much the expenses mount in the hands of criminal lawyer. Remember one more thing, that insurance companies would not cover you from criminal liability. They are liable only for civil liability. Ladies and gentlemen, towards the end, I would just say that dwell on these points. Every patient you treat is a potential litigant. Insure heavily, negotiate with insurers to give you good terms. Inform the insurance company the moment you feel that there is something amiss, the moment you feel you smell rat. Engage your lawyer wisely. Do due diligence, because integrity of the lawyer is a must. Co-opt a medico-legal expert, that will save you a lot of trouble. Be involved in the case with these two, that is lawyer and medico-legal expert, right from the word go. Defense in State Medical Council should be very strong, robust and stout. In District Consumer Dispute Redressal Commission, mediation may be the key. Prudence is most important. Weigh the odds of going in appeal versus paying up. Presenting a united front by the doctor and hospital against the complainant is far more effective than doctor and hospital fighting separately. I've just put this not in my main matter but in the summary, because most often what happens is that the hospital and the doctors are on the different sides of the table, and the problem goes because of blame game. Be at good terms with your CMO and local SHO. You are God, next to God, noble profession, charity. These are the phrases which need to be assigned not to the history but possibly the dustbin. Work sincerely to the best of your ability, but don't take it to the heart. Thank you very much, ladies and gentlemen. I'll take my seat if there are no questions. Thank you.